It's just before 3 in the afternoon on a weekday in Crofton, Maryland. Jody Torok is home alone in her apartment, talking on the phone with her close friend Blair Wolf, who lives in Pittsburgh. They talk regularly. It's the kind of friendship where you can call just to chat. There's a knock at the door. A man says he's a salesman. Jody tells Blair she'll call her back in a few minutes. She never does. Blair waits. She calls back. No answer. Calls again. Nothing. Growing worried, she reaches out to Jody's housemate, Jessica Higgs, and asks her to go home and check on Jody. Jessica finds Jody unconscious on the floor, bleeding from a gunshot wound to her head. Jody Torok was pregnant. She survived. Her unborn baby did not, and she would live the rest of her life with serious permanent injuries from that afternoon. When police examined the crime scene, they found no sign of forced entry. Jody had opened the door to whoever shot her. On the floor, near where she lay, they found a shell casing and a bullet from a .380 caliber cartridge. And they found something else, something strange, a Gatorade bottle, but not an ordinary one. The upper part was wrapped in 2 layers of tape, white medical tape underneath, silver duct tape on top. There is a rectangular hole cut in the tape over the mouth of the bottle, and at the bottom, a jagged hole with edges bent outward as if something had punched through from the inside. None of Jody's neighbors had heard a gunshot that afternoon. The prosecution's theory: someone had turned that Gatorade bottle into a homemade silencer. I'm Mucho Balinda, and this is The Third Voice, where we translate Supreme Court decisions into plain English so you can understand what the court actually said, what it means, and why it matters. Today's case is Klein v. Martin, decided in January 2026. It's about a man convicted of helping to orchestrate the shooting of his pregnant girlfriend. It's about evidence the prosecution never turned over, and it's about a question that cuts to the heart of how our justice system works. If the government breaks the rules, but you probably would have lost anyway, does that count as fair? Charles Brandon Martin had been dating Jody Torok for about a year when she told him she was pregnant. She believed the baby was his. Martin was not happy about this news. In fact, he was furious. He demanded that Jody get an abortion. She refused. She told him she intended to take him to court for child support, and she threatened to tell his wife, or his baby mom, about the pregnancy. I want to pause here because this detail matters. Charles Brandon Martin wasn't just some guy Jody was dating. He had other women in his life. At least 3 other girlfriends appear in this case. Jody's pregnancy threatened to expose a life Martin had been keeping carefully compartmentalized. A few weeks after Jody told Martin about the pregnancy, he sent a text message asking what time she worked that day. She replied that she was off, meaning she should likely be home. Later that same day, she was shot. The evidence against Martin was, in the Supreme Court words, strong. Start with the Gatorade bottle. Jody's housemate Jessica testified it wasn't on the floor when she left for work that morning. Both Jody and Jessica said they didn't drink Gatorade, didn't keep it in the apartment, and wouldn't have left a bottle lying on the floor. The bottle had apparently been brought there by whoever shot Jody. A hair was found on the tape covering that bottle. DNA testing showed that while 99.94% of the North American population could be ruled out as the source of that hair, Charles Brandon Martin could not be ruled out. Additional traces from at least 3 people, including at least 1 male, was found on the mouth of the bottle. Testing ruled out 96% of the black population as potential sources. Martin, who is black, could not be ruled out. Here's what that means in plain English. Martin's DNA on the bottle that the prosecution said was used to silence the gun that shot Jody Toro. Then there was the eyewitness testimony, a man named Michael Bradley. The brother of yet another of Martin's girlfriends testified about what happened at his sister's house on the afternoon of the shooting. According to Michael, he was there with Martin, his brother Frank, and an acquaintance named Jerry Burks. They were smoking marijuana. At some point, Frank went upstairs and came back with white medical tape. Martin and Frank then went upstairs together. Frank came back down, grabbed a Gatorade bottle, and headed back up. When police searched that house, they found the same kind of white medical tape that was in the bottle recovered from Jody's apartment. Michael Bradley also testified that Martin and Burks left the house together before 2 p.m. They were still gone when Michael returned from picking up his niece around 3 p.m., right around the time Jody was shot. When Martin and Burks finally came back, sometimes before 6:30, Martin handed Frank a brown paper bag and said, "Get rid of this." The prosecution suggested that bag contained the murder weapon. Police never found it. They also never found the .380 caliber handgun that federal firearm record showed Martin owned, the same caliber as the bullet that nearly killed Jody Toro. Multiple witnesses testified they had seen Martin with a small semi-automatic pistol in the weeks before the shooting. And there was one more piece of evidence. Another girlfriend, Sherry Carter, testified that Martin had kept a laptop at her apartment, one he said he'd gotten from a former employer. She said she had seen Martin using that laptop to look up gun silencers, not long before the shooting. After Jody was shot, Carter testified Martin took the laptop from her apartment and got rid of it because he didn't want it found there if police searched. The jury convicted Charles Brown Martin as an accessory before the fact to attempted murder. He was sentenced to life in prison. His conviction was affirmed on appeal, and that might have been the end of the story. Except for what the prosecution never told him. In 1963, the Supreme Court decided a case called Brady versus Maryland. The defendant in that case, John Brady, had been convicted of murder. After his trial, he discovered that the prosecution had withheld a statement from his accomplice, admitting that the accomplice, not Brady, had actually done the killing. The Supreme Court held that the prosecution's failure to disclose this evidence violated Brady's right to due process. The court established a rule. Prosecutors must turn over evidence that is favorable to the defendant. If they don't, and that evidence is material to the case, the defendant is entitled to a new trial. Here's what that means in plain English. The government has to play fair. If they have evidence that could help you, they can't hide it. That sounds straightforward. But here's a catch, a big one, built into the word material. We'll get to that. After his conviction was affirmed, Charles Brandon Martin sought what's called post-conviction relief in state court. And he raised a Brady claim. He argued that the prosecution had failed to disclose a forensic report, one that had analyzed 5 computers found at his home. Remember Sherry Carter's testimony? She said Martin had been using a laptop from a former employer to research gun silencers. Well, one of those 5 computers was exactly that, a laptop issued to Martin by a former employer. The forensic report found no evidence that this laptop had been used since 2005. And when investigators ran keyword searches for terms like handgun, Gatorade, silencer, and homemade silencer, they got no hits. Nothing. The prosecution never gave this report to Martin's defense team. Now, Martin argued that this was the laptop Carter had described. If the defense had known about this report, they could have used it to destroy Carter's credibility. You said you saw him researching silencers on this laptop. The forensic analysis shows it hadn't been used in years and had no such searches on it. You're lying. The state post-conviction court agreed with Martin. It ordered a new trial. But Maryland's Intermediate Appellate Court reversed. Yes, the court acknowledged the prosecution should have disclosed that report, but the court concluded the report wasn't material under Brady. Why? Because even if the report had totally discredited Sherry Carter's testimony, the other evidence linking Martin to the crime was so strong that there was no reasonable probability the verdict would have been different. Here's what that means in plain English. Yes, the prosecution broke the rules, but you probably would have lost anyway. So it doesn't matter. Martin appealed to the Maryland High Court. They declined to hear his case. He asked the Maryland Supreme Court to review it. They also declined. So Martin turned to federal court. Here is where I need to tell you about another law, one that dramatically changed the landscape for people like Charles Brandon Martin. In 1996, Congress passed the Anti-Terrorism and Effective Death Penalty Act. Its acronym is AEDPA, pronounced EDPA, by lawyers and the judges who have to say it a lot. It was passed in response to the Oklahoma City bombing, and one of its goals was to speed up executions by limiting what Congress saw as endless appeals by death row inmates. But EDPA didn't just affect death penalty cases. It fundamentally changed the relationship between federal courts and state courts when it comes to reviewing criminal convictions. Here's what that means in plain English. Before EDPA, if you were convicted in state court and you believed your constitutional rights had been violated, you could ask a federal court to review your case. The federal court would look at the constitutional question fresh, as if it were deciding the issue for the first time. After EDPA, federal courts can only grant relief if the state court's decision was contrary to or involved an unreasonable application of clearly established federal law. The Supreme Court has interpreted this to mean that federal courts must give state courts the benefit of the doubt. A federal court can't overturn a state conviction just because it thinks the state court got it wrong. It can only act if the state's court decision was so wrong that, in the Supreme Court's words, every fair-minded jurist would disagree. That's an extraordinarily high bar. The court has called it protection against extreme malfunction in state courts. You don't just have to show error. You have to show that the state court blundered so badly that no reasonable judge could have reached the same conclusion. Now, there are arguments on both sides of whether EDPA is good policy. Supporters say it respects federalism, the principle that state courts are competent to decide constitutional questions and shouldn't be routinely second-guessed by federal judges. It also promotes finality. At some point, a conviction needs to be final. Endless appeals aren't good for victims, for the system, or even for defendants who need to know their fate. Critics say EDPA has made it nearly impossible to correct constitutional violations, even obvious ones. They point to cases where defendants have been executed despite serious doubt about their guilt or the fairness of the trials, because federal courts felt constrained by EDPA's strict standards. Both of these perspectives have merit. We'll come back to that tension. When Charles Brandon Martin filed for habeas corpus relief in federal court, the district court granted his petition. The court found that the prosecution's failure to disclose the forensic report violated Brady, and that the state court's contrary conclusion was unreasonable. The state appealed to the Fourth Circuit Court of Appeals. By a divided vote, the Fourth Circuit affirmed. The majority acknowledged that the state court had correctly stated the legal rule for Brady materiality. But the majority concluded that the state court hadn't actually applied that rule properly. They had, in the Fourth Circuit's view, focused too much on whether there was enough evidence to convict Martin and not enough on whether disclosure of the hidden report might have changed the outcome. Judge Niemeyer dissented, arguing that the majority had defied AEDPA standards of review. Maryland asked the Supreme Court to intervene. The Supreme Court didn't just agree to hear this case. It did something more unusual. It reversed the Fourth Circuit without even holding oral argument. This is called a summary reversal, and the court typically reverses it for cases where it believes the lower court's error is so clear that briefing and argument are unnecessary. The court's opinion, unsigned, speaking for the court as an institution, begins by acknowledging that AEDPA sometimes put federal courts in a disagreeable position. They may have to deny relief in cases they would have decided differently if they were the original decision makers. But the court says federal courts are duty-bound to comply with AEDPA. The court then reviews the evidence against Martin, the DNA on the Gatorade bottle, Michael Bradley's testimony about the tape in the bottle being taken upstairs, Martin's motive, a pregnant girlfriend threatening to expose him, the text message asking when she would be home, the witness who saw him with a .380 handgun, the brown paper bag he told someone to dispose of, the gun that was never found. Against all of this, the court considers what the hidden forensic report would have added to Martin's defense. Yes, it might have discredited Sherry Carter's testimony about the laptop, but Carter's testimony was just one piece of a much larger case. And the court notes that a fair-minded jurist could easily conclude that even without Carter's testimony, the other evidence was overwhelming. The court criticized the Fourth Circuit for essentially imposing opinion writing standards on the state court. Under AEDPA, a state court doesn't have to write a detailed opinion explaining its reasoning. It doesn't have to discuss every piece of evidence. What matters is whether its ultimate conclusion was reasonable, not whether its opinion satisfied federal judges. The Fourth Circuit had faulted the state court for not being sufficiently nuanced in its analysis. The Supreme Court essentially says, that's not your job. Your job under AEDPA is to ask whether any fair-minded jurist could have reached the state court's conclusion. Here, the answer is yes. The court reverses the Fourth Circuit and sends the case back with instructions to deny Martin's petition. Justice Jackson, alone among 9 justices, would have denied the state's petition for review. She didn't write an opinion explaining why, but her vote suggests she believed this case at least deserved full briefing and argument before the court decided it. Now, I want to pause here because something unusual happened in this case, or rather, something unusual didn't happen. This wasn't a 5-4 decision along the usual ideological lines. This was 8-1. 8 justices from Clarence Thomas to Sonia Sotomayor agreed that the Fourth Circuit was wrong. Only Justice Jackson wanted to even hear argument before deciding. So what did the Fourth Circuit see that the Supreme Court didn't? To understand this, I need to explain a distinction that sounds technical but matters enormously. There's a difference between asking, was there enough evidence to convict, and asking, is there a reasonable probability the outcome would have been different if the hidden evidence had been disclosed? The first question is about quantity. The second is about effect. You can have a mountain of evidence, more than enough to convict, and still have a situation where one hidden piece might have changed how the jury saw everything else. The Fourth Circuit looked at the Maryland court's analysis and essentially said, you claimed to apply the Brady tests, but you didn't actually do it. You listed all the evidence against Martin, noted that there was a lot of it, and declared the case closed. You didn't seriously wrestle with how the hidden forensic report might have shifted the jury's perception of the whole case. Think about it this way. Sherry Carter's testimony wasn't just one piece of evidence among many. It was a connecting thread. She said Martin researched silencers on that laptop before the shooting. That ties him to premeditation, to planning, to the specific method of the crime. That Gatorade bottle wrapped in tape. Pull that thread, and maybe other things start to unravel. Maybe the jury looks at the DNA evidence differently. Maybe they question Michael Bradley's credibility more carefully. Maybe a reasonable doubt creeps in where it wasn't before. The Fourth Circuit thought the state court should have grappled with this. It didn't. The Supreme Court response was essentially, that's not the question. Under AEDPA, federal courts don't get to impose opinion writing standards on state courts. The state court doesn't have to discuss every piece of evidence. It doesn't have to show its work. It doesn't have to be, in the Fourth Circuit word, nuanced. It just has to reach a conclusion that a fair-minded jurist could reach. And the Supreme Court looked at the evidence in this case, the DNA, eyewitness testimony, the text message, the motive, the missing gun, and said, a fair-minded jurist could absolutely conclude that the forensic report would not have changed the verdict, even if it destroyed Sherry's credibility completely. Here's what that means in plain English. The Supreme Court isn't saying the Fourth Circuit was wrong about the evidence. It's saying the Fourth Circuit asked the wrong question. The question isn't, would we have decided this differently? The question is, could any reasonable judge have decided it the way Maryland did? The Fourth Circuit saw process, how the state court reasoned, and found it thin, cursory, inadequate. The Supreme Court saw outcome, what the state court concluded, and found it defensible. Under AEDPA, only the outcome matters. Whether that's the right answer, whether we want federal courts to be that hands-off when state courts cut corners, is a question the Supreme Court isn't asking. But maybe we should be. Now, I want to do something a little different, because when a case like this goes public, when people read about it, hear about it, argue about it, they don't all see the same thing. And I think that's worth exploring. Not to tell you which perspective is right, but to show you how the legal system, by failing to explain itself, clearly leaves room for people to fill in the gaps with their own experiences, their own fears, their own assumptions. So let me walk you through some of the ways people react to a case like Klein versus Martin. These aren't straw men. These are real perspectives I've encountered in conversations, in comments, in my own head as I worked through this case. Perspective 1. How often does this happen? Some people hear about this case and immediately ask, if we caught this Brady violation, how many are we not catching? They think about what had to go right for Martin to even raise this claim. Someone had to realize the forensic report existed. Someone had to understand its significance. Martin had to have access to competent post-conviction counsel. The report had to still exist and be discoverable. For people who think this way, Klein versus Martin isn't a story about one case. It's the visible tip of an iceberg. They wonder, how many forensic reports are sitting in evidence rooms right now, never disclosed, never known? How many people are in prison because the evidence that could have helped them was hidden and nobody ever found out? This perspective often comes from people who have seen the system fail, who have studied its failures. They're not paranoid. They're pattern matching. Perspective 2. Other people hear about this case and think, wait a minute. The evidence against Martin is strong. DNA on the silencer, eyewitness testimony, motive, a disappearing gun. Is he just using this Brady violation as a technicality to escape accountability? For people who think this way, the hidden forensic report is a sideshow. The real story is a guilty man trying to slip through a procedural crack. Some go further. They wonder if the whole laptop story was a setup, testimony designed to be discredited later, giving Martin a built-in appeal. It sounds paranoid, but defense attorneys are paid to think ahead. Was this a long game? This perspective often comes from people who prioritize finality, who worry about guilty people walking free, who have seen too many cases where technicalities let dangerous people back on the street. They're not hurtless. They're protecting a different value: closure for victims, safety for communities. Perspective 3. Some people focus on a different question entirely. If Sherry Carter testified that Martin researched silencers on a laptop, why didn't the prosecution verify it? They had 5 computers analyzed. They had forensic capabilities. They could have shown the jury. Here's the search history. Here is proof of premeditation. That would have been devastating evidence. Instead, when the forensic report showed no such searches, they buried it. For people who think this way, that's a red flag. Why wouldn't you want to prove your own witness right? Unless you knew she was wrong, or you didn't care whether she was right as long as the jury believed her. This perspective often comes from people who are skeptical of prosecutorial power, who have seen cases where winning mattered more than truth. They're not anti-law enforcement. They're asking the system to live up to its own standards. Perspective 4. And then there are people who step back and see something simpler and maybe more troubling. They think about the timeline. Carter testified at trial. The defense heard her testimony in real time. When the jury heard it, they could cross-examine, but they couldn't pause the trial to hunt for a laptop and run forensic analysis. The forensic report already existed. The prosecution had it, but the defense didn't know to ask for it because they didn't know what Carter was going to say until she said it. For people who think this way, there's no villain in this story, no grand conspiracy, just the ordinary machinery of criminal trial grinding forward. Witnesses testify in real time. Evidence sits in files that may or may not get shared. Evidence operates under time pressure and incomplete information. The system didn't find the truth, not because someone hid it maliciously, but because the system isn't really designed to find truth. It's designed to process cases. And those aren't the same thing. This perspective often comes from people who have worked inside institutions, legal, medical, bureaucratic. They know that most failures aren't caused by bad actors. They are caused by systems that aren't built to do what we assume they do. Perspective 5. Finally, some people noticed something about the vote itself. 8 justices agreed the Fourth Circuit was wrong. One justice, Justice Jackson, wanted to at least hear the case before deciding. She didn't write an opinion. We don't know her reasons, but some people wonder, what did she see that the others didn't? This perspective comes from people who think about whose voices are in the room when decisions get made. Justice Jackson spent years as a public defender. She represented people the system was trying to convict. She has been in rooms where the human being at the center of a case was sitting right in front of her, not reduced to a transcript, not flattened into legal abstraction. For people who think this way, an 8-1 vote doesn't mean the 8 were right. It might mean something about whose perspective is represented on the court and whose isn't. I spent more than 15 years as an interpreter in federal and state court, and I can tell you, the transcript never tells the whole story. There are things that happen in a courtroom, a pause, a gesture, a phrase that means something different in one culture than another, that don't survive the translation to paper. By the time a case reaches the Supreme Court, it's been flattened. The human being at the center becomes a set of facts to be analyzed. And some justices may have more experience than others in remembering that those facts were once a person. What this tells us: 5 perspectives, all of them reasonable, none of them crazy. And that, I think, is the point. When reasonable people can look at the same case and see such different things, it tells us something, not about the people, about the system. The legal system doesn't explain itself. It issues rulings. It cites precedents. It uses language that most Americans can parse. And then it moves on to the next case, leaving everyone to fill in the gaps with whatever they bring to the table. Some people fill those gaps with suspicion, some with trust, some with cynicism, some with hope. All of them are responding to the same silence, the system's refusal to speak in terms ordinary people can understand. Jody Torok survived that afternoon in Crofton, Maryland, but her life was forever changed. She lives with permanent injuries. She lost her baby, and the man the jury concluded helped orchestrate her shooting will spend his life in prison. Charles Brandon Martin will not get a new trial. The Supreme Court has spoken. The state court's decision stands. But the questions this case raises don't have easy answers. What do we owe to victims? What do we owe to defendants? What happens when those obligations conflict? And who decides? For now, the answer is 9 justices in Washington, or in this case, 8 of them acting without even hearing argument. That's how the system works. Whether it's how the system should work is a conversation worth having. The law belongs to all of us, but right now, it speaks a language most of us were never taught. That has to change. Thanks for watching The Third Voice. If this episode helped you understand something about the law that felt inaccessible before, that's exactly what we're trying to do. Share it with someone who might feel the same way. I'm Mucho Belinda. Until next time.